being brought to us today by Noah Novogrodsky, who's the Carl Williams Professor of Law and Ethics at the University of Wyoming College of Law. He teaches international human rights, public international law, immigration law, and civil procedure. He has a wide array of interests in international relations and has had a number of appointments at Cambridge University and other international posts. Before going into teaching, he was an associate at Arnold & Porter. He is the founding director of the International Human Rights Clinic at the University of Toronto. And he's also been a visiting professor at Georgetown, Connecticut, and at Berkeley. And his scholarship is also focused on HIV/AIDS pandemic, international criminal justice, and transnational human rights problems. So it's a pleasure to welcome Noah Novogrodsky here today for our faculty talk.
Thank you very much. I think I really owe this invitation to my wife, who was a classmate of the dean's at Harvard, and we became friends in Cambridge and have remained connected ever since. So thank you very much to Ruth and Dan for inviting me, for Haya for organizing today's talk. I've circulated a 20-page draft that is just that. It's a draft. It's a project I'm beginning to write and work on, and I welcome any and all criticisms, suggestions, and thoughts. I do not have a PowerPoint, so I'm just going to speak from notes, and maybe I will point powerfully to the screen. International and comparative law scholars have written extensively about the migration of constitutional norms and the practice of high courts engaged in borrowing or cross-referencing decisions from foreign courts. About 10 or 12 years ago, this was a really hot and contentious topic. But less attention has been paid to the question of how effective transnational advocacy occurs, particularly in the area of human rights. And based on recent experiences litigating Obergefell and Hobby Lobby, the contraceptive coverage cases, before the Supreme Court, the draft I have distributed examines how lawyers marshal arguments and favorable case law across jurisdictions to facilitate the adoption or uptake of ideas, particularly when the court doesn't have to. So that is seminal to my argument. My tentative conclusion is that winning transnationalism requires three things. Number one is a direct appeal to first principles, rather than a scorecard of the number of states that have adopted a particular position. Number two, I think it is critical to translate foreign and comparative discourse into well-tested domestic legal norms. And three, this is a pitch that has to be made to judges, not legislatures, to embrace a uniquely judicial function. I think I have a particular, maybe valuable vantage point in that I have litigated human rights cases in a number of national courts and international tribunals, first as the director of the International Human Rights Clinic at the University of Toronto Law School, and more recently at the center I run at the University of Wyoming. A few points to begin with. The most successful migration or borrowing of foreign and comparative law happens when one court decides to learn from the experiences of another country. So we're not talking about international tribunals, which invoke international, foreign, and even scholarly writings into their analysis. For example, the jurisprudence of the Inter-American Court and Commission is, by its very nature, open to diverse inputs as it interprets international legal obligations pursuant to a convention that references more than the founding document itself. And of course, I'm not talking about the informal advocacy and sharing that happens between lawyers and advocates working on a range of issues. There has been a proliferation, for example, of HIV, AIDS, antiretroviral therapy workshops on how to learn from South Africa and Brazil and win expanded coverage of life-saving medicine in diverse countries. That's not the kind of grassroots mobilizing advocacy that I'm talking about. What interests me is how lawyers influence domestic judicial decisions when the court need not, but often does, look to foreign and comparative law. And this is a bone to Dean Hamilton, but the migration of constitutional norms begins with the Commonwealth tradition of harmonizing laws across an empire upon which the sun never set. So it is no surprise that tiny Belize or Sierra Leone would look to the High Court of Australia or the Canadian Supreme Court to resolve the question of whether Mayan communities hold Aboriginal title to lands they have traditionally used and occupied. Or that Lord Mansfield would canvass Blackstone's commercial law to avoid an insurance contract, as he did in the case of Lazang, involving a notorious claim on behalf of slavers who threw human cargo overboard and then submitted a commercial insurance claim to Lloyd's of England. And Lord Mansfield was basically dealing with insurance fraud. He didn't talk about it in terms of mass murder, but he looked to the law of the Caribbean, to the West Indies, to the East India Trading Company, to find that the case in controversy in front of him was void because of Commonwealth common law well-settled principles. Let's call the Commonwealth tradition transnationalism 1.0. And in this historic tradition, we tend to have more borrowing happening in less developed judiciaries from more developed judiciaries. More recently, progressive human rights advocates have sought to extend norms and principles from a place that has adopted their preferred viewpoint to one that has not. So for this proposition, look no further than the case I cite in my brief, which is that Harold Coe at Yale Law School, with former UN High Commissioner for Human Rights Mary Robinson, submitted a brief in Lawrence versus Texas. And there, amici argued or urged the United States Supreme Court to follow the European Court of Human Rights decision in Dudgeon, which struck down a law banning consenting same-sex intimacy. Justice Kennedy's decision did just that, and cites Dudgeon approvingly as confirmation of the court's due process reasoning. He actually cut and pasted a full page of the amicus brief and inserts it into a Supreme Court decision, which, as you know in our line of work, is the gold standard for the uptake of ideas. Liberals were elated and conservatives were shocked and appalled. And the story used to be that conservative voices claimed that what happens outside of our unique legal community is irrelevant to the resolution of the case. This, of course, was the source of Justice Scalia's comment that it is, quote, the U.S. Constitution we are expounding upon, and not any other foreign nation. An analogous situation developed in Australia and India, whose high courts are prone to saying that what happens elsewhere in the world is non-justiciable and a matter for Parliament to decide. So let's call liberal internationalists shopping, substantive shopping, not foreign shopping, bringing law from a jurisdiction where they like an outcome, and conservatives saying, no, 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 you can't do this, transnationalism 2.0. That dynamic did not hold long. The Federalist Society and other more conservative legal groups immediately generated a backlash among like-minded politicians and judicial authorities, evident most famously in Justice Scalia's dissent in Roper versus Simmons, in which he asserted that, quote, "The basic premise of the court's argument that American law should conform to the laws of the rest of the world ought to be rejected out of hand." I actually love reading Justice Scalia in dissent because he is unchecked. Roper was followed by Graham versus Florida, which used international comparative law to ban life sentences for juveniles for crimes not involving murder. But in a related 2012 case, Miller versus Alabama, the court studiously avoided discussion of any non-US sources. At the same time, politically conservative politicians passed legislation purporting to ban the application of Sharia law in places like Oklahoma, and began to ask judicial nominees to pledge that they would never cite foreign and comparative law as the basis for future decisions. The result has been a kind of underground movement among more progressive or liberal justices, most vocally Justice Breyer, who continue to cite foreign and comparative law, but insist that it's not binding. It's simply educational or influential. And now conservatives are emboldened, or in this era we're emboldened, to say that it is malpractice merely to reference foreign ideas. Vicki Jackson called this tension the engagement with the transnational, and noted that justices, particularly at the United States Supreme Court, fell somewhere between adoption and outright resistance. So let's call the backlash era transnationalism 3.0. And most recently, conservatives have changed their tune. Instead of saying that they shouldn't, that the court ought not to look to foreign and international law, they have joined those of us who are in a more liberal camp, and they are doing it with both guns blazing. In 3 cases, a coalition of amici organized by BYU law professors have taken the position that foreign and comparative law means that the United States Supreme Court ought not to recognize same-sex marriage, that it should recognize religious objections to contraceptive coverage, and that the death penalty is just fine because other countries adopt it. Their basic argument is that their views are, quote, fully compatible with international norms and case law. That is no different than what liberal internationalists have been doing. The briefs carefully qualify the salience of international practice. So in Obergefell, the BYU brief said, of course, foreign law and practice cannot and should not determine the meaning of U.S. constitutional guarantees. But foreign and comparative experience stands as an empirical resource, a lesson for the court to do with what it did. Why do I know that they use this particular paragraph? Because I wrote it in the brief that was filed 2 weeks earlier. And so they cited my language, the Obergefell brief that I submitted, and are in complete agreement that international and comparative law is not binding, but it is nonetheless persuasive. So now, this body of law is being used on both sides of the debate, and I'm trying to understand when it works and when it doesn't. So let's call this transnationalism 4.0. And one explanation is that it depends on who submits the brief. So respected organizations and individuals might gain traction for their views, but fringe voices do not. And there may be some truth in this, but I'm suspicious of the argument because it ignores the craft and substance of a growing practice. So instead, I have identified 3 admittedly self-serving factors that I think contribute to winning transnationalism. And why do I call it winning transnationalism? Because we've been winning in these cases. where the court does look to foreign and international law. And where the court does not look to it, we claim a draw. So that, again, is, kind of a particular gloss on it. So the first argument I make in the paper is that any court that doesn't have to follow precedent directly is going to be more interested in an actionable reference to values or ideas that exist both within and outside the state, and that speak to our first principles. To do so requires the advocate to address the reasoning behind things like international human rights treaties, use cogents norms, or explain why a decision is likely to echo from one jurisdiction into another. This is the dialogic appeal, and it obviously plays better in those cases involving matters that have consequences beyond the state's borders: citizenship and immigration, indigenous rights, same-sex marriage involving partners of different nationalities, reproductive freedom, particularly where women are being pushed to terminate pregnancies in other countries, internet speech, universal crimes, all issues that I think exceed the interest or capability of any one state to fully regulate. And here, comparisons matter. Plainly, some countries and contexts count more than others. And the trend matters as well. In Obergefell, we argued with great effect that the Irish referendum on same-sex marriage, that it happened after the initial briefs were filed, but before the Supreme Court decision came down in June of 2015. Remember, at that time, the United States Supreme Court was 6 Catholics and 3 Jews. In fact, Neil Gorsuch is the only Protestant on the court. So again, appealing to Dean Hamilton's legal history, I'm guessing this is an anomalous situation, that we have had some WASPs on the court for a long time. And that a predominantly Catholic court is a new phenomenon, and one, frankly, where the Catholic precedent from Spain, Portugal, Argentina, and Ireland can be particularly influential. The BYU brief basically tallies up all the countries in the world that don't accept same-sex marriage and said the United States Supreme Court should feel comfortable doing the same. And we said the 25 countries that we are most like do accept same-sex marriage, and that what we really need to talk about is a trend and a relevant comparator rather than a stock number. And we further raise concerns about the United States Supreme Court joining Cameroon and Nigeria and Egypt as anti-models. And according to Justice Kennedy's clerk, that was a deeply persuasive argument. Now, this is anecdotal, but Harold Coe seeds all of the Supreme Court justices with clerks, and so he was all over which arguments were working or having traction, which ones were not. Second argument, translation into the domestic. It's absolutely essential to situate the issue in a domestic tradition. The Mary Robinson, Harold Coe brief in Lawrence versus Texas does a masterful job of noting that foreign and international law echoes domestic understandings of decisional privacy, relationship privacy, and zonal privacy. And here, I would not argue that advocates opposed to the death penalty cite to the Universal Declaration of Human Rights, an aspirational document, as a recent Colorado attorney did. Instead, I think the more effective strategy is to ground the foreign comparative and international law in in a principle that finds traction in well-tested domestic traditions. As a corollary to this, I think that that domestic tradition is going to be more amenable to foreign inputs, and it is interpreting something like what constitutes cruel and unusual punishment or what is a dignity-based interest than it is the interpretation of a specific statute. So to the extent that Hobby Lobby addressed whether an employer, a private employer, could refuse to provide contraceptive coverage under an amendment and a side interpretation of Obamacare, it was a particular statutory inquiry. And I think that the foreign and international law has enjoyed greater uptake in those cases involving a big open-ended principle than it does statutory interpretation. And finally, I think this is an appeal to judges. Judges are curious about how other judges interpret the world. And on a question like whether two people of the same sex can get married, there is no dissonance or gap in understanding. So the Canadian and South African and Argentine judges adjudicating that question were speaking directly to Justice Kennedy and Justice Breyer on the issue of what is same-sex marriage. They had confronted the same arguments, that there was a procreative rationale for limiting marriage, civil marriage, to opposite-sex couples. And they had cited U.S. law, particularly the Massachusetts decision. And there is a kind of transnational dialogue going on of and between judges. Contrast what New Zealand's parliament did recently after the mosque massacre. New Zealand's parliament didn't look to any other country's exemplar in banning high-powered assault rifles. And in fact, I looked at the 6 hours of debate transcript. There is not a single reference to what any other society has done. I think judges are more capacious in their understanding, more curious, and feel like they have the scope and authority, particularly in the Anglo-American tradition, to learn from the experiences of other jurisdictions. I want to leave this presentation with 3 questions that I'm grappling with, and not to shape your questions or comments, but I could use feedback on these 3 points. Number 1, how empirical should this article be? I have a fantastic research assistant. I have some life experience litigating transnational cases, but I'm reluctant to engage in an enterprise of looking at hundreds of transnational cases and trying to establish a data set that would determine when the arguments are more effective than others. That seems like a political science project, and frankly, I'm less empirical in my orientation. But I don't think, gleaning principles from 3 or 4 cases is enough, and because I'm not named Cass Sunstein, I'm concerned about how that will land when I publish. Number 2, if experiences of other states matter, which states matter? Justice Breyer was pilloried in a debate at Washington College of Law, AU's law school, by Justice Scalia for citing a Zimbabwean court. Frankly, the courts in Zimbabwe are fantastic, and they're the only bulwark against authoritarianism. But Breyer admitted that it was a mistake to cite Zimbabwe for anything, and provided ammunition to his critics that we are better and different than Zimbabwe, and we ought not to be citing them. Forget for a minute that many Zimbabwean judges come from Oxford and are casebook authors of material that is cited by our Supreme Court. You recognize that the optics of that were not good. But I do think it is different to cite the Canadian Supreme court or another venerable body, and my question is, which comparators matter? And the third question really has to do with subject matter. Are certain kinds of cases more amenable to comparative or foreign experience analysis? So I welcome your thoughts, comments, criticism, and thank you for having me here today. Yes.
So fascinating. I love reading about this and hearing about this. You had your three inquiries, and my question and comment doesn't directly address those, but kind of indirectly does, because my own background of late, at least, is that I focus a lot on psychology and thinking about psychology of persuasion. So when I, heard you and read your thing earlier, I just kept thinking about, I kept thinking about this from a psychological standpoint, because it really, to me, and it's not the only lens, but to me, it's ultimately a psychological question: what's going to be persuasive and why to this audience of these judges? And to me, the psychology, and you actually get at this in some of what you talked about today, I mean, to me, it ultimately is going to have a lot to do with just who are those justices? If you're talking about our Supreme Court, it's not at all surprising to me that in some cases they do and in some cases they don't look to the international law, not so much for these very big picture principled reasons that you're talking about, but for much more petty pragmatic reasons like, is it going to help the argument or it's not going to help the argument? Or I think you're also right that it could be that certain justices, from their background, their Catholicism, or for whatever reason they have a deep-seated either embrace of looking to foreign stuff or hostility to look to foreign stuff. So Scalia, in one case at least, I don't know if that was more uniform, this one, no, we can never ever look to foreign stuff, whereas other justices do seem more inclined to look to it. So I think to some degree the psychology is going to bring you to the same place. For example, what the psychology of persuasion would say is that statistics are not usually very persuasive. Stories are much more persuasive. So that would, kind of be a parallel to your own conclusion of, 25 countries versus 14 countries. That's not a very persuasive thing, but it might just be a rich vein for you to pursue is
I think that's absolutely
bottom
right.
line of comment. Yeah.
And I've been thinking about this in terms of what I would call the psychology of sovereignty. But think about the New Zealand debate recently. There was a sense in which an Australian came to New Zealand to massacre Muslims at prayer, and that part of the enterprise of Parliament was to reclaim sovereignty over the issue of gun rights and to speak for the nation as a whole. And to do that by subordinating the national interest to a foreign story, I think would have been almost offensive, right? In part because the killer was clearly speaking to an international audience and trying to pick up on ultranationalist trends that have found deep expression in other societies. I think that we're talking about how do you persuade judges to do something that is unfamiliar. In my experience domestically, judges do not like to be told that they don't have jurisdiction over a particular issue. An ineffective argument is you can't hear this controversy. In fact, I have been in court and won otherwise losing cases because judges are like, you don't think I can hear this case? Watch me, right? Particularly Article 3 left-handed judges. And I think the psychological component is key, and I agree that we're talking about master narratives and which stories appeal and which lenses appeal to judges. And I've got to think that a transnational problem being adjudicated by a high court in a given country is more likely to benefit from a very similar story adjudicated by a similarly positioned authority. And that's got even more than psychological appeal. It has a kind of tradition or custom as well.
So, very interesting. Want to hear more and more. I have many questions, which I can't quite articulate into specific questions, so maybe I'll just pre-associate for a minute. So, first I want to know how much of an outlier is the United States? I mean, do other countries?
It's a huge outlier.
It is a huge outlier.
I mean, we are traditionally an example of American exceptions. Other states have all sorts of practices, seminars. Yale Law School runs a constitutional seminar every year for high court judges from around the world who are basically like learning from each other on digital privacy, on intellectual property, on reproductive rights. There's a theme each year, and they go there to learn about the decisions, particularly in the developing world, that they're not going to hear about on Lexis or Western. And so Breyer goes to that annual seminar, but very few other Supreme Court justices do. And he's the outlier within a court that is an outlier among other high courts.
That's interesting.
And Anne-Marie Slaughter has written extensively about this, this practice of how judges learn from each other.
So, that's interesting. For the empirical question, so brutally, sort of brutally reductionist, there's a common law tradition, there's a civil law tradition.
Right.
They are both transnational within their spheres.
Right.
I'm curious how often they cross-pollinate, if at all. Meaning, one thing I would be curious about is, do the common law judges basically list the only common law other nations, and is that, do they stay in their lane?
Right. I know much more about the common law tradition, obviously, and not only do the common law judges stay in their lane, but there's the big four. Like when you go on safari in Africa, there's the big five. So the big four are now Canada, Australia, UK, or House of Lords, and South Africa. And there are lots of citations to the big four, much more than Pakistan's very politicized Supreme Court, or smaller Caribbean countries, or East African nations. And it's interesting that the common law world has sort of reinvented itself as a highly cross-referential society. I've worked on indigenous land claims where courts have stayed proceedings pending something happening halfway around the world. So like they want to know in Belize or in Jamaica what's going to be happening in Australia or India that month. I think that's really interesting.
Is there a civil law analog, do you think?
Not only is there much less of that tradition, but the civil law tradition has gone in a different direction lately, trying to influence international or multinational tribunals more than, you're interpreting a code in the civil law tradition, and that is, I think, fundamentally a different exercise than gathering stare decisis from.
But what's interesting is that it started with the same code, right? It all started with Justinian's code.
Right, but
They're now
different paths. Yeah. And you would know much more about that than I do. But
and I'm fascinated by the subject matter question, because I bet that is, in large part, the answer. Right?
Yeah, I'm noticing that there's more cross-pollination in big open-ended questions involving things like equality, dignity, and liberty, or very narrow technical questions like banking law. And in Morrison, which was the case about whether Australian securities purchasers could rely on their version of the 1933 and 34 Securities and Exchange Act, no problem looking to what other states have done on that exact same technical interpretive question.
You see, that doesn't surprise me, because the answer is always history.
Right.
And,
legal history.
Right? And there you might find sort of lex mercatoria,
Right.
alive and well,
Right.
fine today in a sense.
Right. But the statutory questions of Obamacare or the exclusionary rule in other countries are these kind of in-between first principles cases or technical expert.
And last one I promise, and then I'll stop, Ruben, is, and you threw me a curveball with BYU, because then there's this Judeo-Christian gloss that just complicates everything, that might also be transnational in its own unique way, that is fascinating, which I never thought of before.
Yeah, and if you, so here I'm just going to be fully transparent. I have worked closely with Harold Coe on a number of these cases, and we have adopted a model that less is more. So we are part of this trend of small, influential amici rather than huge lists of every organization that lines up on your side of the issue. BYU goes in a very different direction. So there are 139 European, mainly Catholic university professors talking about theological and Catholic legal traditions in Europe for their views in Hobby Lobby and Obergefell. These professors and organizations are not nearly as influential as the folks we have on my side, if you will. But, oh, and by the way, Vicki Jackson at Harvard is she is the leading centrist transnational scholar. So like everybody wants her on their brief. And she was appointed a special master in the Prop 8 case and Hobby Lobby as well. And so, and she writes in her book about engagement, which is a totally neutral green chicken shit term for how we're doing this work, right? It's interesting. I think a lot of these conservative, particularly Catholic institutions, want to be on the record as having discomfort publicly with changes in society. And interesting that, Wyoming is about 20% Mormon, and I teach public international law, and a lot of my students have come back from missions. So it's no accident that BYU is interested in the international sphere. They just have a very different gloss. And I think it's fascinating that they have quieted the critics of using international authority in the conservative camp. And like now their voice, I think their view, I don't, hang out with them and talk a whole lot, but their view seems to be if you can't beat them, join them. And nobody is saying that foreign and international law is immaterial. Yes, sir.
I have a couple of quick comments about a question. One is that almost 40 years ago, when I was still in law practice, the Ninth Circuit at that time came out with some kind of a ruling statement to the effect that unpublished opinions weren't law. And that prompted a bit of a debate, and in our law firm at least, we went ahead and sided it anyway, on the premise that if they told a story and they were persuasive precedent, whether they were quote unquote law or not, right? And I think that fits nicely with this whole thing. The other thing I thought was interesting was that Justice Scalia, even though he doesn't want to cite any other sources, in Romer made almost an identical argument that opponents of the Civil Rights Act of '64 made. And it just seems to me it was implicitly kind of a referencing back to that kind of an argument, and that was really not rooted in American constitutional law or anything. So the argument that it's illegitimate to cite sources beyond the American Constitution just seems to me to be borderline silly.
Right. Well, Justice Scalia, at the American Society of International Law, actually qualified his Roper comment. And he said, I'm an originalist, and I cite foreign law as just the law of the UK. And it's the law that was in place in another jurisdiction before we came into existence. So, interestingly, in the three Guantanamo Bay cases, Boumediene, Hamdi, and Hamdan, he is consistent in holding that the writ of habeas corpus has a pre-United States history. He cites to the Magna Carta, James Oldham at Georgetown fashioned a brief on habeas to Scalia that he heavily adopted in those Guantanamo cases. And I thought that was an interesting use of legal history, and it allowed him to marry his hostility to foreign and comparative law from the last 240 years with his frequent invocation of the original texts. And I think on the unpublished decisions, you were clearly ahead of your time. I mean, it doesn't matter whether opinions are published or unpublished. In fact, in immigration law, as some of you may know, the immigration law listserv is peppered with this disseminating effort to publish by pushing out all sorts of decisions that are then cited even though they're not published, because we know that they're influential. And actually, last night I was getting ready for today's talk, and I wrote down all the vocabulary that has been used by the Supreme Court, twisting itself in knots to say that foreign and comparative law is not binding, but it's something else. So it is influential, it is persuasive, it is instructive, it is educational. The list goes on for all of these terms that mean you can use it or ignore it as you wish. But how to marshal that body of material and in what kinds of cases is an open question. And now that this is being actively done, at least in the legal academy, I thought I might say something about when it seems to be more effective than at other times.
Hi, yes, thank you. This is really fascinating. I take you up on your question about subject matter and the Eighth Amendment in particular, the death penalty question. So I was unaware of the movement on the more conservative side towards accepting a kind of transnationalism. But I'm wondering if that is going to be an interesting area to keep close eyes on, just because it's not going to line up the same way as the Rügefell, since the Catholics theoretically are on order from the Pope, and I mean the Catholic position on the death penalty is against the death penalty.
Right.
So both sides of interest there in making transnational arguments may be coming out the same way on it, looking at other countries like Ireland. I mean, it's just a thought, but so that's on one side. You can imagine more movement there for political reasons, and where those political sides derive their ideas and thoughts. But on the other side, like the Eighth Amendment to me has sort of, the justices have really written it into a box they can't get out of, in a way that isn't true about the 14th Amendment.
Right.
It isn't true about, so whereas the rest of the world is talking about dignity and
Right.
punishment, we've written it out, and it's
Right.
very hard to get it back in. So I wonder if that is going to be
Yeah, I mean, we could talk for hours about the contradictions in what I perceive to be the conservative camp's arguments. I have a feeling these BYU professors will not go to the same lineup of Catholic jurists in Europe for arguments around the death penalty in the future, and that they have an agenda, and they are cherry-picking international arguments and exemplars that serve their view. And the question is whether we're doing the same thing on our side of these cases. I think we are, but I'm trying to suggest that we're doing it with style or principle in ways that my adversaries may not be doing, and that could just be disclosure, that could just be a self-justificatory exercise. I will say one more thing about we are in a really globalized transnational world. So the day after Hobby Lobby was decided, the dean of the Opus Dei Law School in Santiago in Chile published an op-ed basically saying, that's it, no more contraception in Chile. Like, we have now been blessed by none other than the United States Supreme Court. And, I mean, the Chilean context is totally different, but in real time, in the public arena, these legal arguments are being used and adapted. And so I would suggest that what we do has outsized influence, and that I think the BYU professors are right that this is a trend or a genie that can't be put back in the bottle, and that they are now participating in the conversation rather than insisting that judges have no right to cite outside of the country. Yes, sir.
Thanks again for your talk and for your paper. First, I do have a comment that's going to segue into a question. So one thing about the whole BYU conservative camp is that, interestingly enough, the reason why the majority of countries still have some pretty bad laws in terms of LGBT rights and such is because of the history of British colonialism, that those old common law colonial codes are still on the books in a lot of these countries. So in some ways it is a remnant of colonialism. Right. Which then gets to kind of the question, because you asked, who should we be following? And if the big four are Canada, UK, South Africa, and Australia, doesn't it just become another type of self-propagating colonialism in terms of these are the attitudes of these countries that are just perpetuating among themselves? If we're now saying, well, okay, these are the ones that people are going to cite, and it's going to just proliferate among itself so that it's going to continue to marginalize other places like Zimbabwe or parts of Asia and such.
Well, this bleeds into the subject matter question from before quite nicely. We are definitely seeing a retrenchment of a very conservative position on LGBT rights in the developing world. And it's a violent and persecutory trend, right? Likewise, on capital punishment, there were a bunch of countries in the Caribbean that withdrew from the Privy Council because the UK had abolished the death penalty, and they wanted the death penalty for drug trafficking and homicide. And so Trinidad and Jamaica and a bunch of other Caribbean countries have institutionally objected to the new mandarins of the UK, and it's interesting. In one instance, they are taking the colonial heritage of anti-sodomy laws and investing that with new demagogic and violent legal capacity. And in other contexts, they are saying, you can't tell us what to do. We don't like your modern, we don't like your jurisprudence, or we don't like your statutory legacy. I think in a sense it is all politics. India's decision on the now infamous or notorious Section 377 anti-sodomy cases is really interesting. I think it is clear that the Big Four are producing a kind of globalized jurisprudence that other states are not, and that there is a backlash to that new trend as well.
So this is very intriguing, particularly, I think, in the context of a world that seems so much turning inward so much, some nationalism on the rise in the United States and in other countries. And so the idea, this talk and the title, which can basically rephrase transnationalism is winning, right? Is very intriguing given all these other trends that we see in the context of the world today. So I guess the first question I have is really about how is that counted, right? You know, you talk, is this a descriptive or an explanatory paper, or is it normative? Like, what is the, I guess strategic, I should say. What is the best way to make sure that transnationalism is taken seriously, right? And so that's a strategic question, right? But the explanatory question or the descriptive question of, you know, is transnationalism winning, I think is still to be measured, right? And it may not be, of course, this long, big data set or political science kind of, but I think that I guess I'd go to your third question about what empirics should we use to try and determine like this trend, right? And I guess the first one that seemed to me would just be, are we seeing more citations to foreign law, you know, on a continuum, not just in the Supreme Court, but, you know, in all federal courts, let's say, or some data set. And then the question might be, where is transnationalism going?
Right.
On this Supreme Court, right? And so to that, of course, I ask you to opine about Justice Kavanaugh, Justice Gorsuch, you know, and Justice Roberts, Chief Justice Roberts, in terms of where you think they're going to be headed in this continuum.
Well, I actually think that in a world of inward-looking ultranationalism, where states are adopting strongly sovereigntist views on contentious social topics, I think this paper has particular relevance because now we're asking, when does one authority cite another one? When they don't have to, when they are not linked by some shared enterprise. I'm not expecting the Hungarian or Polish ultranationalist captive Supreme Courts to suddenly start looking outside of their borders for solutions, but I wouldn't be surprised if the borrowing and migration of ideas is defined or confined to some areas and proliferates in certain areas and not in others in that world. There's another conversation going on, which I think you alluded to, and that really is how are ultranationalist societies or renationalized societies responding to international institutions? And can they really withdraw in a globalized world? But the European conversation has a lot to do with trying to get out of the European Court of Human Rights, which used to be the ante for getting into the common market. You had to join the court, and now a bunch of illiberal Eastern European countries, plus the UK, are chafing against that. I think that's a similar dynamic to what's happening in regional authorities, and some countries don't want to be governed by the international or regional level anymore, and that's a somewhat different inquiry as to which ideas are adopted by the undisputed interpretive authority at the apex of different countries.
Do we get any tea leaves from the hearings, or at least the early opinions of Gorsuch and Kavanaugh in terms of where they might be going with this?
Well, I think Chief Justice Roberts, as I note in the paper, is suspicious of the transnational borrowing, and he joins Jeremy Waldron and some others in saying that this is just like looking out over the crowd and picking the hats out of the friends that you like. I mean, there's no principle to this practice. It's just you know, now that Westlaw carries decisions from St. Lucia, we can we can cite them at will. I think that there was a very interesting case in 2005 in which Roberts actually opined at length on what he was doing. And it's called Sanchez-Llamas, and it has to do with the exclusionary rule. And he basically says liberals are going to have to own the fact that we are different in terms of criminal law than other societies, and that U.S. exceptionalism can be good at times and can reach results that liberal internationalists don't want at other times. International courts don't have the hearsay rule. They don't have the exclusionary rule. They're not oriented with the same suspicion that our institutions are. And I think he is likely to be a more consistent, selective borrower than the newer justices on the Supreme Court. I say this as a Yale Law grad, but I think Justice Kavanaugh is he's a complicated figure, and I think that Justice Gorsuch from my district, from the 10th Circuit, and he is going to inaugurate a new law school building on our 100th anniversary next.
She said.
I think that he really does see himself in the Scalia mold, and he's authored a couple of opinions already on criminal justice matters that are more progressive than you might expect from him. But I don't expect him to be a transnationalist. I would love to talk to Justice Breyer, who, O'Connor was a strong transnationalist, and going to the, Rehnquist would go to this seminar in Austria every summer. Some of you are more familiar with that than I am, and be involved in this judicial dialogue. And I don't think that was just because it's lovely there in July. I think it's because he was quite interested in that conversation. No indications yet that Justice Gorsuch is doing that. The other thing about Justice Kavanaugh is I think he was in some ways brutalized by the process, and I'd be curious to see. He does not want to take an abortion case in the next 3 years. He does not want to take an abortion case while Susan Collins is still a sitting senator. And you're starting to see that already. He is not voting to grant cert in contentious cases. So I don't think we know enough yet about his practices. I think we know a lot about ourselves and our society based on his confirmation process, but I don't think we know much about his church groups.
Hi, any other questions? Yeah.
Ask me about a question about the state, what state we should look at. I don't see any problem of looking at like Zimbabwe. I think the only thing that really truly transnational is logic and reasoning. So should we actually look at the fact instead of the country, which the opinion is from, to actually maybe migrate so the logic over?
Well, I think Pete Hamilton alluded to this. I think that the lex mercatoria, the private law borrowing, is deeply rooted in all societies, and certainly the problem solving and logic of small-scale debates is significant. But there's an optics problem when it comes to public law matters from countries that are really basket cases. And I think, as I said...
Is that us? Are we in that now?
I don't know. But I do believe that we're... I know that Justice Breyer regrets the symbolism of his looking to public law in a society without a lot of the fundamental legal infrastructure that we have here. And I think that's why I'm asking the question of which comparators are going to be more influential going forward.
It's like he regretting for doing it, or he regretting for being part of doing it?
Clearly the latter, but maybe the former as well.
Thank you so much.
Thank you.